and thank you for joining us for Procurement and Government Contracting Compliance. My name is Dan Cotter, and I'm privileged to be your moderator today. This webinar is part of the Financial Poise webinar series, Corporate and Regulatory Compliance. Slide 7 provides a summary of the series, and Slide 6 summarizes this episode in particular. Thank you to our co-producer and sponsor, the National Law Review, and for those that don't know about them, you can learn more on Slide 3. Speaking of the slides, you should understand from the get-go that we will not step through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like every Financial Poise webinar, is a conversation with the panelists, and so we'll get into it in a minute, and you'll be in for a treat, these two experts that we will soon introduce. However, keep that PowerPoint handy, because I'll try to indicate what slides our conversation is touching on as we proceed, so you can take notes, and you'll have those after the seminar as well. Our panelists today are Aaron Felix, partner at Polsinelli, and Habib Elahi, partner at Schertler, Honorado, Mead & Sears LLP. And as mentioned, my name is Dan Cotter, and I'm a partner at Dickinson Wright. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us on slides 44 through 47 in your slide deck. We truly, as I mentioned, have a great panel of experts today in terms of breadth of experience, varied practices within the government contracts arena, and perspective from both lawyers. And you're going to soon see the time and energy and the expertise that they bring to the table. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to www.financialpoise.com or shoot an email to info@financialpoise.com with the word subscribe in the subject line. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can always send an email to info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get you an answer. Today, we're talking about procurement and government contracting compliance. And when we look at that, the volume and complexity of transactions related to procurement are some of the reasons that transactions with the government are most vulnerable to corruption. State and federal regulatory compliance can be tough to navigate, and the process can make even routine sales and marketing practices vulnerable to civil and criminal liability. This webinar analyzes the regulatory framework, including identification of some of the legal risk in solicitations, pre- and post-award bid protests, contract compliance, change orders, and contract claims and disputes. The webinar also discusses defense strategies of a company that is accused of fraud or civil noncompliance. The questions, and now we're going to get into some of the questions. We're going to start with Aaron, and against this landscape, Aaron, of compliance pervading all aspects of a company's life in the market for government contracts, that's significant. The Department of Defense, for example, was the largest government purchasing agency in the last fiscal year, procuring everything from aircraft components to vehicles to electronic equipment. Its spend was over $100 billion based on public data. There's a lot of subcontract that goes on. Against this entire landscape, Aaron, generally speaking, what are the areas of compliance that involve procurement and dealing with the government that this whole arena involves?
Yeah, thanks, Dan. It's interesting because, as you said very aptly, the government contracting compliance landscape really covers the waterfront from a lot of different perspectives, both through the life cycle of a government procurement, as well as across functional areas, operational areas, as well as areas that are sort of less visible. So it really is pervasive, is probably the best word I can use. So when we think about government contracting compliance, we think about issues that can arise either prior to or during the bidding process. This can be things like, is a company even qualified to submit a bid? Does it have a proper pre-registration with the government in the system for award management? Has the company thought about its supply chain and teaming relationships in terms of who they're going to bid with, and have they structured those pre-bid agreements properly? Have they thought through their conflict of interest potential risks? And different types, as we'll talk about, I think, different types of procurements have different rules. And so, for example, is the government buying something that's considered to be a commercial product or service? Because those rules are very different than when the rules are in play for non-commercial products and services. And that's just in the pre-bidding side. You also have challenges in the bidding process itself. The government, as much as it tries to do the right thing, doesn't always get things exactly right. And so there could be inherent problems in the solicitation process itself, in the way the bid is being asked for, or how the government evaluates bids. And so their contractors can think about compliance from the perspective, is the government doing things right? And are there ways to make sure the government is doing things right if we think things have gone sideways? Once you've gotten past then the bid and award stage, then you get into performance. And that is really sort of the meat and potatoes of where we see compliance and the rubber hitting the road. We have what I characterize as both operational compliance, which tend to be the more visible types of compliance we think about. Are we, painting the ship the right color? Are we torquing the screws to the right level of tightness? Are things being made in the way the customer is expecting? And those tend to be a little bit more apparent, but no less important. We have supply chain related issues. We have things like cybersecurity related issues. But then we also have what I would characterize as the less obvious regulatory compliance type of obligations. And these are things that aren't necessarily going to be apparent to the customer and the government in terms of whether you've complied at the time you've completed final delivery. Have you hired your personnel in accordance with the various hiring rules? Have you paid people correctly? Have you made sure that your cybersecurity is properly managed? Things that are less visible but equally important from a contractual and compliance perspective. And then lastly, certainly not leastly, the issues can arise from a compliance perspective just in the disputes process. The government is, again, not perfect, and just like any set of contracting parties, there can be disagreements about what the contract says and who's responsible for what, and that can include compliance requirements. And there are very specific rules, processes, and procedures around how a contractor raises a dispute, flags that, and can bring that before the government. So compliance from a procedural standpoint becomes important as well.
And from my experience, and we'll turn to kind of compare the private versus public, but my experience and from what you're talking about, this seems like something that someone without a lot of knowledge of this whole process, you need experts like yourself or Habib to get involved, just because it sounds like a pretty complex process with all the government overlays and requirements. So something to keep in mind. Let's turn to what drives compliance in government procurement, and how do you think it's different from private procurement practices?
Yeah, you're exactly right. It can be a really major landmine for companies who don't necessarily appreciate that there are some significant distinctions. Because in part, fundamentally, when we step back, what we're dealing with is prudent and transparent use of taxpayer money. And that's really what drives all of this as we talk about the unique rules with government procurement. And so because the government is properly stewarding taxpayer money, there's significant oversight of compliance, and even something as basic as a firm fixed price contract, where the price is pre-negotiated and the delivery is pre-negotiated. The government has significantly more insight and oversight into compliance, even in a contract like that. Also, because at the end of the day, the government is still a sovereign entity. There are certain types of rights by virtue of the fact that the government is what it is and does what it does that can't be negotiated away. There are certain things like very standard commercial clauses around indemnification by the customer. The government won't provide open-ended indemnification by matter of statute. It can't. Likewise, the government, because it always needs the ability to potentially redeploy its resources in the event of a war or an issue or change in priorities, there's a very broad termination right that the government has that you don't typically see in the commercial industry. Likewise, On the selling side, very standard commercial sales practices can be highly risky or even illegal in the government contracting perspective. There are ethics rules around that both the government personnel have to abide by, and on the flip side, government contractors around providing gifts and meals during this, to government employees. Hiring and recruiting conversations with government people who may be leaving the government sometime in the near term, how competitions are run and what information can be shared. And so these practices that companies that are used to dealing in the commercial space that are very normal, in many cases on the government contracting side, are very not okay. And then just very quickly, I'll jump to what I'll talk about, what I'll call some of the tactical compliance differences. And that is when you think about government contracts and compliance, in the commercial world, the contract says what the contract says. The parties are free to negotiate, and at the end of the day, you have a contract that has four corners, and it is what it is. In the government contracting world, those things are driven by a number of different factors that all sort of overlay. You have different award types, whether the contract is for goods or services. There are different compliance obligations that can come into play. Which federal agency is in the purchaser can change what the rules are around particular types of compliance obligations. Is the government buying commercial, as I mentioned, something called commercial products or services, or non-commercial? How much is the procurement for can trigger different compliance thresholds, and whether a company is the prime contractor dealing directly with the government, or if they're a subcontractor lower down in the supply chain, can also affect what obligations flow to them. So there are a lot of just it's an intermingled web, I think is the best way to say it, that just you see a complexity that you don't typically see in the commercial world.
Well, that's great. And we're going to turn now, Habib. We're going to talk with you and get your thoughts on main areas of concentration and procurement when we speak of critical issues.
Sure. I mean, as you heard from Aaron, federal government contracting involves navigating a complex web of rules and regulations outlined in the Federal Acquisition Regulations, or FAR, as we refer to them. Also, there are cost accounting standards, and the rules can be overwhelming and time-consuming and very difficult to adhere to. In addition, you've got a series of executive orders that were issued by the current administration, not to mention new enforcement initiatives laid out by the Department of Justice. And federal contracting can be highly lucrative, though. And as the federal government spends over $750 billion annually with its contracting, and that actually makes it the largest consumer in the world. Given that these programs use taxpayer money, though, they're highly regulated, as we've seen, and they have difficult barriers to enter. But we can generally group the relevant areas into 7 buckets. The first is cost pricing issues, and the FAR and the cost accounting standards dictate that it needs to be accurate, and it needs to be complete, and the cost and pricing data must be timely. And you also have to designate fair and reasonable pricing. This is an important component of government contracting. The second bucket is competition and competition conflict issues. In government contracts, competition is crucial for efficiency and cost effectiveness. And while conflicts of interests and compliance requirements are vital for the integrity of the system, organizational conflicts of interests, or OCIs, can arise when a contractor has a dual role, such as evaluating their own products or services, or influencing the bidding process. The third area is used to be non-discrimination and affirmative action, but this administration has radically changed that and is in fact cracking down on what it refers to as illegal diversity, equity, and inclusion, or DEI programs. This is definitely an area to watch, but I'll talk a little bit more about that later. The fourth area are employee and worker protections compliance. These involve wage and hour and drug-free workplace requirements. Some examples are the Service Contract Act, the Contract Work Hours and Safety Standards Act, and the Davis-Bacon Act, to name a few. The fifth area involves environmental regulations and considerations. Again, it's going to be interesting to see how this administration is going to enforce this area as well. That's to be determined. The sixth bucket involves security, including cyber and information security compliance. This is going to be a major area of enforcement, which I'll go into a little bit more later. And finally, we have supply chain compliance. Government contractors are required to comply with, stringent supply chain regulations, particularly as they relate to national security and ethical sourcing. This includes monitoring their supply chains for potential risks like counterfeit parts or human trafficking, but also adhering to domestic sourcing preferences under the Buy American Act and Trade Agreements Act. Back to you, Dan.
So a lot to digest, and again, I think already 15 minutes, 16 minutes in, whatever we are. For the listeners, those that are not that familiar with this area, it's not your old-fashioned private contracting. There's a lot of other overlays, as you mentioned, and a lot of moving parts, as you mentioned, including, we'll talk about later, the minority-owned businesses and where that may be going or not. And so let's turn to when we look at some of this stuff, what is one of the biggest or most significant policy considerations when developing a compliance framework to govern public procurement?
I think that government contractors need to keep in mind that ethics are heavily regulated, as they should be. And government contractors and those doing business with government contractors need to be mindful of the enforcement of state and federal False Claims Act, or the FCA. The federal FCA is a law that imposes liability on persons and companies who defraud government programs. Basically, the FCA prohibits contractors from knowingly submitting false claims to the government or making a false record to get a claim paid by the government. Not only can the government get back the amount that they paid, known as the damages amount, but they can get up to 3 times that amount under the FCA, plus a per claim penalty, which is now from anywhere from $14,308 to a maximum of $28,619 per claim. So if you have multiple false claims under a particular contract, say, for example, hundreds of task orders that were submitted, you can see how that damages and penalties number could get very high very quickly. The problem for a lot of contractors is that you can act knowingly under the statute by acting with reckless disregard for the truth or falsity of the information, meaning that you acted in such a form of gross negligence plus. That's where a lot of well-meaning contractors and good intention contractors run afoul of this statute. It's not the type of intentional conduct that people normally think of when they hear the term fraud, but the FCA is a fraud statute. One of the most important parts of the FCA is its whistleblower provisions, which incentivize whistleblowers to come forward with information by awarding them a percentage of the government's recovery from damages. In fact, the majority of FCA cases arise from whistleblowers. So that's why it's critical for contractors to have a robust compliance program in which your employees actually buy into it and that you regularly stress test. Contractors really need to have this compliance as part of their ethos. And the FCA is a big stick that the government wields, and that's why it's the government's primary tool for combating fraud against the government programs. Some common areas for government contracts related FCA enforcement matters are those that involve progress payment issues, defective or non-conforming goods or materials or services, cost misrepresentations that result in overcharging the government. Defective pricing is an area when you retain overpayments that the government might have made. if there's any bid rigging or collusion, and finally, organizational conflicts of interest. In addition to the FCA, the federal government just this year has a new weapon in its enforcement arsenal, and that's the Administrative False Claims Act, or AFCA. Congress passed the AFCA in December of 2024, and the new law significantly expands federal agencies' abilities to investigate, pursue, and even settle investigations of false claims when companies make false statements when seeking reimbursement through government contracts or government programs. Agencies can now recover double the amount of each claim associated with the investigation, and the costs of the investigation for up to 10 years after the violation. And what's important is that even if a contractor never received any government funds, it could still be held liable under the AFCA for any false statements it made. So the AFCA and the FCA give the government broad and sharp enforcement tools to root out potential false claims. Again, all the more reason to have a robust compliance function as part of your company if you're planning on doing business with the government. One other additional thing, in addition to the FCA, I'd mentioned briefly organizational conflicts of interest, or OCI. They're important because the government wants to make sure that they're awarding their contracts fairly and that contractors don't have conflicting roles. So the FAR requires contracting officers to avoid or mitigate them. And there are three broad areas for which organizational conflicts of interest can arise. If a party has, first, unequal access to information, and that's where a contractor has access to non-public information as part of its performance in a government contract, and where that information could provide the contractor with an unfair competitive advantage in a later competition for a government contract. The other area is if a party has impaired objectivity, and an OCI would arise where a contractor's ability to render impartial advice to the government would be undermined by that contractor's competing interests. So the concern is that a contractor's ability to render impartial advice to the government would be undermined by its relationship to the product or service being evaluated. Finally, there's if the ground rules are biased. OCIs could arise where a contractor, as part of its performance of a government contract, was in some sense set the ground rules for the competition for another government contract and could therefore skew the second competition, whether intentional or not, in favor of itself. So it's important for contractors to be aware of these OCIs or the potential for them. They're a lot more common than one would think. Back to you, Dan.
Thank you. And with the AFCA, as you mentioned, proceed with caution. Like you said, you don't even have to be necessarily get money from it. And so, and the Foreign Corrupt, the False Claims Act was, it's also known as Lincoln's Law, right? Because during Civil War, there was uniforms, I believe, was false statements or submissions. And so interesting, it's been around that long. And whistleblowers, as Habib mentioned, can, if they pursue the litigation, there's different steps of how involved they are. They can get part of the damages or relief. So it's an interesting, very interesting law. And again, you need to really understand that, as well as like Foreign Corrupt Practices Act and all kinds of other things depending on where you're located. So Aaron, turn it back to you. In terms of compliance and procurement, where do we find the sources of law that govern this area of compliance? And probably not an easy answer, but I'll turn it over to you to tell us.
Yeah, it isn't as straightforward as one would hope. And again, so I think one of these areas that distinguishes itself from commercial contracting. There are really, I would say, 6 main sources of compliance and procurement rules or obligation, sources of obligation that companies want to think about or contractors want to think about as they're looking at their contracts and obligations. The first, as Habib mentioned, is the Federal Acquisition Regulation. That really is the foundational starting point for the vast majority of agencies. There are certain agencies that are, for example, the Federal Aviation Administration, the Postal Service. There are certain agencies that are not subject to the FAR, but the vast majority of federal agencies are. And the FAR is the common denominator starting point for federal procurement compliance and process. In addition to that, each federal agency has its own supplemental, or the opportunity to have its own supplemental rules. So you have the Department of Defense FAR supplement, the DFARS, you have the Department of Homeland Security supplement, you have the IRS supplement. So these tailor the FAR for the individual missions of each agency. In addition to, both the FAR and the agency supplements are formal federal rules. So these go through the rulemaking process. On top of that, then you have within federal agencies, just like you do within large corporations, the less formal directives, memos, internal policies, internal processes around this is just the way we do things. That may or may not be codified in law, but it is very much codified in process in the mind of the agency. Then, number 4, I'll keep going, is federal law itself. Now, a lot of the federal statutory requirements end up being codified in the FAR, in agency supplements, and so you see a lot of duplication. But there are federal laws that meaningfully affect government procurement that don't necessarily show up in contract clauses, FAR clauses. For example, federal fiscal law and appropriation law. There are rules around how and when money can be spent, and that spending process affects how, when, and under what circumstances the government will spend money. The Contract Disputes Act. I talked about special forums and timelines and processes for bringing disputes with the government. The Contract Disputes Act under procurement contracts covered by the FAR provides this very specific process that you don't really see show up in your contracts. Likewise, there's a statute called the Anti-Assignment Act, which prohibits contractors from assigning a contract to another party. And so these, again, don't necessarily show up in a contract, and so they can be less visible for companies that aren't looking out for them. Moving on then, particularly when we're in the world of the supply chain and subcontracts, you have state and local law then that plays an aspect, because a subcontract or a purchase order tends to be what we call a hybrid agreement. It's a partially a commercial agreement governed by state law, things like payment terms and normal business practices, but then you have these federal flow downs and overlays on top of that. So you have sort of yet another layer of complexity. And then finally, the individual terms of the contract itself. So just like any contracting party, the government can include in a federal contract unique terms and conditions relating to that particular procurement and what they're buying. And so all of these other factors will play into that, but ultimately the contract can have its own completely standalone and independent provisions as well. So lots of different moving parts.
And then moving parts is right. You mentioned agency regulations and directives and memos, and you got the Chevron doctrine and the Auer doctrine and all the other stuff. But you also have executive order from the administration that said any regulations won't be enforced, right? Yeah. So all this stuff. And so again, tread carefully as you go through kind of this whole list that Erin just mentioned, because there's a lot of overlay and a lot of moving parts is, I think, the takeaway today. But in addition to the policy-based and legal compliance requirements we've discussed so far, what would you say are some recent hot-button compliance challenges facing government contractors today? And there's a lot, so pick a thing or two, because there's so much going on again with a lot of with the new administration. It always happens, but this one's really active and really frenetic. And so, give us a few things that maybe people should be thinking about in this whole kind of moving parts arena?
Sure. I think for me, hot button compliance challenge number one would be cybersecurity implementation. Cybersecurity remains a top priority for federal agencies, and there's a rollout of the cyber security maturity model certification, or CMMC 2.0 framework, that has brought new compliance expectations. And what used to be voluntary adoption of cybersecurity risk management has now turned to regulatory standards and a new era of broad and seemingly ever expanding oversight. There are new rules from the Securities and Exchange Commission, the EPA, the FTC, the FCC, and TSA, as well as from states like California, New York, and Texas. And as the number of these cyber attacks increase, there are new disclosure requirements from government agencies. And the Biden administration actually created the Office of the National Cyber Director to try and harmonize the regulations. And it's still being supported by the Trump administration, but companies still need to get in front of the competing regulatory requirements. Also, with emerging technologies involving AI, the need for cybersecurity compliance only increases as all of those initiatives are intertwined. There's also continued False Claims Act risk because the Department of Justice announced the Civil Cyber Fraud Initiative, and that was started in 2021, but it's been going since then. Has been specifically targeting contractors who don't meet cybersecurity standards or misrepresent their security protocols or fail to report incidents. Just last month, DOJ announced its ninth cyber-related FCA settlement under the initiative. So cybersecurity compliance is critical area for contractors. Another hot button issue, I think, is supply chain and Buy American Act scrutiny. And there are executive orders that have proposed regulations and reinforcing domestic sourcing requirements. And I think contractors are going to need to carefully assess their supply chains to ensure compliance with the BAA and TAA. And running afoul of those could lead to some serious contract termination or FCA liability or even possible debarment. And finally, I couldn't end without mentioning the January 21st, 2025 executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which carries significant implications for contractors. It was also followed up very recently by the Department of Justice issuing a memorandum stating that it'll use the False Claims Act to target recipients of federal funds, including contractors, that the agency determines engage in providing diversity, equity, and inclusion DEI preferences that violate federal civil rights laws. And the memorandum notes that the FCA is implicated when a contractor or recipient of federal funds certifies that they've complied, that they're in compliance with federal civil rights laws, while knowingly engaging in quote, racist preferences, mandates, policies, programs, and activities, including through DEI programs that assign benefits or burdens on race, ethnicity, or national origin. And there's even a newly created civil rights fraud initiative with the Department of Justice, and there's going to be a group of prosecutors who are specifically focusing on enforcing this area. So it's going to be interesting to see how these enforcement actions unfold, but it would be prudent for federal contractors to really prioritize the reviews of their existing DEI programs and make sure, to assess any potential claims that those programs would violate federal civil rights laws, as this administration construes them. So those are kind of the hot button areas that I see.
Nothing to think about to keep you up at night at all.
Yeah.
Aaron, let's turn to the contracting process itself. And what are the main procedures the federal government uses to award contracts to companies and people that do their work?
Yeah, there are various types of procurement methods. And as I was mentioning earlier, some of this ties back to what the government is buying, how much they're spending. There are a lot of different factors that can play into the types of procurement methods the government has at its disposal. One of the things that underlies government procurement and is a fundamental concept is the idea of full and open competition. Again, sort of getting back to that 50,000-foot policy of spending taxpayer money prudently, the government has a strong preference, and not just preference, but obligation to maximize the use of competition as much as it possibly can. There are opportunities where either competition doesn't make sense, or there's exigent circumstances, or a number of identified exceptions where the government can go to a single source and say, we're going to contract directly with you versus running a competition. But that is very much the exception instead of the rule. So I would start by saying competition as the baseline, with sole sourcing or going to non-competitive means as an exception. The next, I would say, duality beyond that then is the idea of contracting by negotiation versus sealed bid contracting. So the government can, in instances where it is very easy to, or not very easy, where it is the government can very clearly identify what it is buying, what the specifications are, and it can be extremely clear around what it needs. The government can use what's called sealed bid contracting, where an invitation for bid is issued, and companies back in the old paper days, companies would submit their proposals literally in a sealed envelope, and those envelopes were all opened physically at the same time in a public place, and essentially the lowest priced compliant bid would win. And you see this sometimes in construction, you see this in sort of very, I would say, again, very specification-driven contracts. As products and services procurements become more complex, though, where variations in price don't necessarily directly correlate to variations in what the government needs, because companies can fulfill a contract in different ways. The government can engage in what's called contracting by negotiation, which is more of what you think of in the commercial world, where the buyer issues a request for proposal, says, here's what I need to go buy. And then the government identifies very clear award criteria under minimum compliance obligations, the factors under which the government is going to weigh its award decision, things like price, things like past performance, things like trade-offs in quality, or minimum versus maximum ranges of what it wants versus what it must have. And then the government receives proposals, and then it can then engage in negotiations to better the offers before it makes a final award. So sealed bid and contracting by negotiation is another duality that we think about. And then there's something called simplified acquisition procedures, where the government is buying much smaller dollar procurements, where essentially the risk is lower to the government simply by virtue of the dollars being spent. The government can use some streamlined procurement procedures, either to simplify the solicitation and proposal process. In the case of very small procurements, what are called micro purchases, $10,000 or less, the government can use a credit card. So there are different ways based on what the government's buying and how much it's spending.
And that's the federal level. Do the procedures differ for state and local contracts?
They sure do. As much as there's variation and complexity at the federal level, one of the useful things about dealing with the federal government is that it has these baseline set of rules, and you can largely learn the playbook and know what rule books you're operating within. When you're dealing with state and local governments, there's a wide spectrum of maturity or just existence of whether they even have rules and statutes. Some states and jurisdictions have very robust procurement statutes, regulations, ordinances, just like the federal, almost like the federal government. Other states have maybe 2 paragraphs in their entire state code, and a lot of it's done by by just experience, and this is how we do things. So it can vary wildly, and the level of information that's available to contractors around what that process is and how it's been deployed in the past can vary wildly in terms of just what level of transparency and awareness.
One of the things, Aaron, that we sometimes see the terms responsive and responsible in context of government procurement. Can you briefly tell us what those two things mean?
Sure. So I think the main thing to keep in mind when we're talking about responsive versus responsible is that responsive is a descriptor of a bid or a proposal, whereas responsible is a descriptor for the contractor or the bidder themselves. So when you think about is a proposal or a bid responsive, the operative question is, does the proposal comply with all of the material aspects of the solicitation? Does it meet the minimum requirements? When it's responsible, whether a contractor or bidder is responsible, the operative question is the contractor, proposed contractor, capable of performing the work that's being asked for? And is this a company that can and should be trusted with taxpayer resources? One of the things to know in particular is that the government is specifically required to make what's called an affirmative determination of responsibility for every procurement. So the FAR requires that no purchase shall be made unless the contracting officer makes this determination. So it's something that shows up in every procurement, even if it's not particularly visible.
So even those little small contracts that could be paid by a credit card, even those, they have to have that?
Even those include an affirmative determination of responsibility, although again, the level of inquiry will change.
Okay, great. And if you don't win an award, is there a way to challenge the contracting process or results? And if so, how?
Yes, there is. So I mentioned at the outset that the government tries to do the right thing, but it doesn't always. And so the bid protest process exists to allow contractors and bidders to either challenge a solicitation prior to the award of a contract, or evaluate or challenge the award process itself, which is called a post-award contract. So companies will file bid protests for a variety of reasons to ensure fair terms in a solicitation, sometimes to force a competition. I mentioned sole source contracts as the exception. There's a process to challenge the government if a company believes that a sole source contract is improper, to prevent or correct errors in the evaluation of a proposal, and as well as to prevent the loss of work if you have a company that has historically had the award and believes that it should continue to have the award. There are a number of different venues that a contractor can file in, 3 different options in particular, and each body will have a different authorized scope of review. So the most, I would say, the lowest level of challenge can be what's called an agency level protest, where the protest is brought with the procuring agency itself. There's a streamlined review process. The filing obligations are minimal. There can be some questionable legal value of such a protest, because there's a little bit of a belief that you have the fox guarding the hen house and the agency is evaluating its own procurement proprieties. But again, agencies certainly have overturned their own decisions. What I would call probably the most common venue for bid protests is the Government Accountability Office, GAO. This is a legislative body that has started as the Government Accounting Office back in the day, and it falls under the Comptroller General. And now its scope has expanded. It's called the Government Accountability Office. And this is an administrative forum that exclusively, their bid protest section exclusively evaluates bid protests day in and day out. That's all they do. There are some benefits of going to the GAO in terms of they have a 100-day time frame, so we have a very discrete timeline. The government's represented by agency counsel. It's certainly an adversary process, but you have this within a more administrative confines. And then the third venue is the Court of Federal Claims. This is, you're in federal court. So the agency is represented by the Department of Justice. You don't have any sort of automatic rights other than filing for an injunction and doing all the good things that you do in federal court when you have have litigation. And just like in federal court for other issues, there isn't necessarily a timeline by which the judge has to resolve the case. And so these can drag on longer, and typically you see more complex protests end up at the court.
Perfect. Habib, can you tell us what basic penalties are available, both criminal and civil, for procurement violations? And I know there's a lot of them, so.
Sure. I like to explain penalties in as part of an enforcement spectrum, where you begin with administrative penalties. These happen at the agency level and could involve anything from changes to the contract due to incorrect information provided to the government, to the rescission of a contract in the process of being awarded, or terminating an existing awarded contract, which all could involve monetary damages. These actions could also potentially result in suspension or debarment from participating in federal programs and contracts. And while this is a suspension and debarment are an administrative agency decision, they can actually be fatal for a business that relies heavily on its government business. So it's a serious concern. The suspended or debarred contractors are prohibited from receiving a prime or a subcontract award from any agency unless the agency head determines that there's a compelling reason to deviate from that suspension or debarment order. Moving over to the middle of the enforcement spectrum, you move into the civil enforcement arena. And the big one there is the False Claims Act that we had just talked about. But calculating damages in government contracts matters can be complicated. And it's a hotly contested area in the courts. And there's no universal formula, but you have to start with, what damages resulted because of the defendant's, the contractor's acts. So, for example, if the fraudulent conduct involved the delivery of defective goods, the damages would be the difference between the value of what was received and the value of what should have been delivered. In the case of fraudulently obtained contract, the damages could be all the claims for payment made under the contract, even if the claims themselves were not false. So these types of penalties can be extremely high, in the hundreds of millions of dollars. So it's critical to keep those in mind. And then finally, we get to the end of the spectrum, and these are criminal penalties. And these types of penalties generally come into play when the conduct is deemed willful, which is a heightened knowledge standard. And there are a variety of criminal statutes that the government can use to address fraud in government contracts, with the main one being the Criminal False Claims Act. It's similar to the Civil False Claims Act, except the knowledge standard requires the defendant to have known that he or she was violating the law and intended to do so. The punishment can be up to 5 years in prison and a fine of up to $250,000. There's also 18 USC Section 1031, which is major fraud against the U.S. It's similar to the Criminal False Claims Act, but here, if the volume of the contract is more than 1 million, the maximum sentence increases to 10 years. Oftentimes in government contracts cases, the government will use the false statements statute, which is 18 USC 1001. It's one of the federal prosecutor's favorite statutes. Any materially false statement made to a federal agent during an investigation could be a violation of this statute as well. Penalties could be up to 5 years imprisonment and $250,000 in fines. There are some other criminal statutes that come into play, but I'll cover those in a bit.
Okay. And why don't we turn to types of conflicts of interest that arise under the revolving door of public and private life?
Well, the revolving door between public and private is very common in the procurement world, especially here in Washington, D.C., where I practice. You have a lot of federal agencies and a lot of public and private companies that do business with federal offices. And when these employees leave the federal government, particularly if they served in a procurement or procurement adjacent role in the government, they can be very valuable to companies given their experience. And whenever these employees leave government and join the private sector, however, There are particular statutes that govern what they can and cannot work on. The statute that covers this is 18 USC 207 for post-employment restrictions. And then there's 18 USC Section 208, which governs what current government employees must do if they're seeking employment. Let's say you're a contractor that does a lot of work for the Air Force and you hire a former technical expert from the Air Force to work on a procurement for you. If that former Air Force employee participated personally and substantially on a particular contract or project or matter, she would not be allowed to participate or work on that same contract or project as an employee of your company. There are some exceptions, and it's possible you could get a waiver, but that's the general rule. Additionally, if she was working on a contract matter on behalf of the Air Force, and your company already obtained the contract or was bidding on the contract, she would have had to disclose that to the Air Force that she received a job offer from your company and either not continue to work on that contract while she was with the Air Force or reject the job offer. The whole point of these restrictions is so government employees don't have a conflict of interest to do something that might not be in the government's best interests because they would soon be compensated by a company that's doing business with the government. Its purpose is to maintain the integrity of the procurement process, but also to make sure that the government isn't being taken advantage of. One thing to keep in mind is that both 207 and 208 carry civil and criminal penalties, and oftentimes defendants get convicted of the criminal offense and are then required to pay civil damages in a separate action. These restrictions are very detailed, and there really aren't many scenarios that the regulations don't take into account. So it's important to know the applicable restrictions well. It's also critical that you adhere to any agency guidance that may have been provided to you, such as your Office of Government Ethics letter if you're leaving the government. That letter is usually the government's Exhibit A in any prosecution or enforcement action. And the civil and criminal penalties aren't the only concern. These types of conflicts of interest can also serve as a reason for why your employer doesn't win a contract or loses a contract if there's a bid protest. So it's a tricky area.
Let's turn to discuss for us program procurement, not program integrity.
Sure. And procurement integrity, it's defined as the ethical, legal, and procedural standards that govern the acquisition of goods and services to ensure fairness, transparency, and accountability throughout the procurement process. And its key elements are fair competition, that's ensuring that vendors and bidders are treated equally and given a fair chance to compete, confidentiality, which is protecting sensitive government information or procurement information, such as bids, proposals, or cost estimates from any kind of unauthorized disclosure. And then there's conflict of interest avoidance, that's preventing individuals involved in the procurement process from having any personal or financial interest that could improperly influence decisions. And then there's compliance with laws and regulations, that's the FAR, the cost accounting standards. And then prohibiting conduct, avoiding prohibited conduct, such as any kind of bribery, kickbacks, or bid rigging, or other corrupt practices. And there's actually even a federal statute called the Procurement Integrity Act. It's 41 USC 2107 to 2101 to 2107. And it applies to all present and former government officials and certain other individuals. And in short, it prohibits them from knowingly disclosing any contractor bid or proposal information or source selection information before the federal agency, before the award of a federal agency procurement contract. And it prohibits other individuals from obtaining that information before the award of the contract. Any kind of employment with bidders, it prohibits any bidder seeking employment while involved in the procurement decision. And finally, it covers the accepting of gifts from contractors and potential bidders, which can't occur. And violations can lead to serious consequences, including criminal penalties, contract termination, debarment from future contractors. So you have to keep in mind that some states have corresponding state procurement integrity rules. So I'd make sure that you're complying with that for any kind of state contracts that you might have. These are serious consequences. And recently in Maryland, near the District of Columbia, a former USAID, U.S. Agency for International Development official, pled guilty and admitted that he accepted bribes from a consultant and other contractors to steer agency decisions on over $552 million worth of federal contracts. And so the government contracting officer admitted that he manipulated the agency's procurement process for over a dozen contracts while accepting these bribes. And this contracting officer shared confidential bid information that gave the contractor an unfair advantage, and the contractor ended up winning these contracts. So it's important, for government contractors to be mindful of procurement integrity.
Yeah, a lot to digest. And with a few minutes left, Aaron, any other requirements outside of the ones we've discussed that deal with internal compliance requirements for government contractors? Any suggested best practices you would give our viewers?
I think it's fair to say that we've hit the tip of the iceberg in terms of government contracting compliance. There are lots of things we haven't talked about, but I think of those that we haven't, what I want to flag is and underscore something that Habib has said a couple of times, which is having policies and procedures, having a method for compliance, having identified roles and responsibilities so that a company can repeatedly build in a culture of compliance and demonstrate that to an enforcement agent and auditor is critical. And so having a designated belly button person who is your compliance manager or it's your contracts manager who is keeping an eye on all of these moving parts. No single person can be responsible for everything, but you need someone who is managing, herding the cats and keeping an eye on new contract clauses coming our way, new requirements, and how are we as a company handling these so that we're ready to demonstrate how we're meeting it. So that would be one, I think, just best practice and critical aspect. And then the other thing sort of in that line that we haven't talked about from a compliance standpoint is I do want to underscore intellectual property issues that can come in from a compliance standpoint. And companies that are receiving federal funding and using that money to either further their IP roadmap, develop adjacent IP or augment existing IP, or even just license or sell existing IP to the government, there are some unique rules when government money comes into play around the rights the government gets, and companies can very quickly and easily inadvertently give away their farm without realizing it. So if you are a company in that space or a subcontractor, you really want to make sure that you've got someone advising you on that, because it gets very, very complicated very quickly, and it's very easy to do something you'll later regret. So I think that's probably all we have time for now, but lots more to talk about in a future day.
Perfect. And our last question, what happens if you're going out to get business and want to talk to a potential client? You want to go to coffee or lunch to discuss what you do, what you're selling? Are there any rules that apply?
Yeah, there are. If it's a government client, you're in a whole different world. The general rule is that anything that has monetary value is considered a gift. And government employees may not accept a gift from anyone who is giving the gift to the employee because of the employee's government position. So government contractors, or those who are seeking business with government contractors, are known as prohibited sources, and government employees cannot accept gifts from them, whether or not the government employee is doing business with them. Additionally, if the government employee's duties affect an individual or company, that an individual or company is also considered a prohibited source. So what about lunch? A prohibited source, or if the meal is offered because of your position, then you can't accept the lunch. What if the lunch is under $20? Yes, you can go to lunch or other meals under the exception for gifts valued at $20 or less, but not on a frequent basis. as the guests of the same person because there's a $50 per year limit on gifts from any one source. So no fancy lunches, but what about coffee? You can drink as much free coffee as you want. Inexpensive food and refreshment items such as donuts or sodas can also be accepted. They're not considered gifts. So to sum it up, the $20 exception may be used to accept any gift that is under that amount, but keep in mind that the rules allow you to accept gifts under $20 but not ask for it. Secondly, you can only accept it on a single occasion, meaning that if several gifts are given at the same time, their total value can't exceed $20. Finally, there's a $50 a year per limit on gifts from the same source. Just remember this as the 20/50 rule. But what about gifts from family and friends? There are exceptions to receiving gifts based on personal relationships, but they're subject to certain limits and have some conditions that must be met. When it comes to gifts, just whether you're giving or receiving, you want to steer clear of 18 USC 201, which is the bribery of a public official, and also the Anti-Kickback Act of 1986, particularly when you're dealing with government contracts and procurement.
A lot to consider, and audience, this concludes our webinar. Hopefully you as much as me got a lot of useful information from Aaron and Habib. Thank you for joining another entertaining yet educational production of Financial Poise. And with that, we're at the time and a little over. So be well, everyone.